Hi, good afternoon. We're just waiting for a couple participants and we can then start the session. Maybe you can confirm that you are seeing me and you can hear me, please.
I confirm, Kevin Cicluna.
Thank you, Kevin. Perfect. So if you can mute yourself, please, for the time being, we avoid the echoes. Perfect. So we're just waiting for one more participant. Okay, let's start. So, welcome to the first session of this course. My name is Karl Sammut. I'm a lawyer specializing in technology. Data protection is one of our main areas of practice. And in the course of these 3 sessions, we should have enough time to get a general grasp, an advanced grasp of data protection and GDPR. Unfortunately, due to COVID, we cannot meet face-to-face. However, Lead have made a very, very impressive setup. We're in quite a mini studio, TV studio. It's quite impressive, so congratulations for making it a point that this session can be held. Maybe to break this digital divide, maybe I can go over the names of each and every one of you, and you can give a good basic introduction as to your name and what you do, areas of practice and stuff. Just 1 second. Okay, we can start. So, Alexander McAuliffe, can you introduce yourself, please?
Hello, can you hear me first of all?
Yes, perfect.
Okay, perfect. So basically now I'm running my own business for the last 4.5 years. I work in IT, provide a number of services. And before that, for 8 years, I was running the IT and operations departments of a foreign bank. It wasn't a branch, but the actual bank was operating in Malta, licensed in Malta as well. And before that, I used to work with a group of companies. And the reason I'm doing this course is because I intend to start offering DPO services. So basically, this is why I would like to attend this course.
Very good. Welcome, Alexander. Next participant is Anais, I believe.
Yes, Anais, correct. Good afternoon, everyone. So my name is Anais, and I have been working as insurance compliance officer for 3 years. And I just got a new job for an insurance company, and I felt like I needed to get a deeper understanding of the GDPR. And so that's the reason why I mainly signed up for this course.
Thank you. Francesca? Francesca?
Maybe you need to unmute, Francesca.
Hello. Hi.
Hi, Francesca.
Hi, I'm a lawyer by profession. I work at the Central Bank of Malta, and I deal a lot of data protection issues, and I would like to enhance further my knowledge in this area. Thank you.
Perfect. Okay. Joanna?
Hello, I'm Joanna. I'm a legal officer and I work at Identity Malta Agency in the ICT department, and I deal with data protection issues on a daily basis.
Very good, Joanna. Joseph Mukallef.
Hello.
Hi, Joseph.
So basically I joined this course because I work in compliance and wanted to know much more on GDPR and to assist me into how to draft policies.
Very good. Jude.
Hello, can you hear me?
Perfect, Jude.
Hi, so my name is Jude. I have a background in HR. I work in the public sector. I will soon be involved. Recently, I switched role, and I will be dealing more with data protection issues. So obviously, I would need to update myself with the latest GDPR law. So I'm looking forward to learn more in this course.
Very good. Kevin.
Hi, good afternoon. I'm Kevin Shikruna. I'm Records Manager at MFSA. I want to attend this course to help me identify more the retention period for certain documentation.
Very good, Kevin. Marek.
Hi, my name is Marek. I'm a consultant for information security. And since data protection is very close to information security, I would like to extend my expertise on that.
Thank you. Melanie. Hello, Melanie. I believe Melanie is not with us. So, Raffaele.
Hi, good afternoon to everyone. I am Raffaele. I work in compliance for an investment firm, category 3. And I'm attending this course because I would like to deepen my knowledge as regards the GDPR and be able to deal on a daily basis with such issues in case they come over, which is very likely.
Very common. Sarah?
Hi, I'm Sarah. I work in compliance as well in the fintech payment industry. I'm actually starting a new role tomorrow in blockchain. I want to do this course to increase my knowledge and get a deeper understanding.
Good luck for your new role.
Thank you.
Tanya? Tanya is not with us. Last participant, I believe, is Julia. Julia, can you unmute yourself, please?
Yes, good afternoon. Can you hear me?
Perfect.
Yes, thank you. My name is Julia. I have legal background and I'm working for law firm WH Partners. Mostly I'm involved in gaming sector and also corporate and other matters. And my work includes tremendous amount of clients' KYC documentation. And this is crucial for me to understand GDPR regulations.
Very good. Send my regards to James and Olga.
Oh, I will do. Thank you. Thank you, Dr. Sammut.
So let's start. At any moment in time, feel free to interject and ask questions, either by using the chat function, or even better, if you unmute yourself and ask questions viva voce. If you want to put your camera on, it's at your discretion. Let's make this as interactive as possible. Okay, first question, and it's not a rhetorical question. more often than not in the course of our work, when we are doing compliance, when we are assisting clients, we get resistance. People do not appreciate that data protection is important. However, as you all know, we are now living in a never more interconnected world where data is being shared and generated in everything that we do. The amount of digital footprint that we leave whenever we use any application is impressive. Thankfully, with us, we have some information security specialists, and they can definitely confirm that every time we use an app, every time we use Zoom, every time we use Facebook to log in to a new application, the amount of data that is being generated and stored is impressive. It's not even impressive, it's scary. Okay, so data protection must be used, must be enhanced to protect our interests. I would like to share with you a case that we had recently assisted on, a very unlikely case, but I want to share this with you as it shows the human element of data protection. So earlier this year, we were contacted by an 80-year-old lady who had just lost her husband. So you would ask, well, what has data protection to do with this? But through a series of unfortunate events, this lady experienced a data breach. And it was one of those genuine cases where it was an innocent data breach, but still had devastating effects. So 3 months prior to losing her husband, this lady also lost her late sister. The undertaker, when preparing the documents to present to the public officers to register the death, instead of registering the death of her late sister, registered the death of our client. To cut a long story short, our client resulted as being deceased. So when the notary was preparing the documentation so that the assets of her late husband became transferred to her, this became impossible. And for the first time ever, and I admit, even though I was working in data protection for more than 10 years, I experienced for the first time ever firsthand the devastating effect of a data breach. This lady was actually lost her identity. She couldn't do anything because her official status was deceased. And unfortunately, it took quite some time to give back the status of a living being to this lady. After showing you one example of the human side of a data breach, this slide shows a share price of a company and the effect that a data breach had on the share value of this company. Devastating effect, I would say, that in 2 days, this particular company lost 50 billion, I repeat, 50 billion of market value. Anyone could guess what this company we're speaking about? It's a company that we all use every day. Julia says Google. Anyone else? Don't feel afraid. I mean, let's make this interactive. It's a social media site, to give you a hint. Jude says Facebook. Julia says Facebook. Anyone else? Rafaela says Facebook. anyone, so yes, it is Facebook. Anyone can indicate the actual incident that generated this loss of share value, this data breach. I believe that most of us would have seen the Netflix documentary this year on this actual incident. Anyone can guess? Alexander says Cambridge Analytica, and it's actually, yes, it's the correct answer. So Cambridge Analytica was harvesting data from Facebook, in an illegal and a lawful manner. And I believe you all know what happened to the elections in the UK and the US. What I wanted to point out in the slide is that any data breach nowadays has a monetary effect, okay? So not just the penalties that the authorities can impose, but also the reputational damage, and if you are listed, reputational damage results in loss of share value. So is data protection something new? The answer is definitely not. So data protection is seen as an extension of human rights. The most important instrument dealing with human rights is the European Convention of Human Rights, 1970. Data protection is seen as an extension of the right to private and family life. And the first international instrument, so the first international treaty dealing explicitly with data protection, is the Council of Europe Convention 108. It's been with us since 1981. And as a side note, there is a very strong Maltese element because one of the main promoters of Convention 108 is actually Maltese, Dr. Joseph Kannataci. And the last time I spoke with him, they are preparing an update to Convention 108. Convention 108 Plus, it will be called, just to take into account the new realities of internet and e-commerce. So I don't want to lose much time on this slide, but what I wanted to make to point out is that in Malta, data protection has been with us since 2001. The Data Protection Act, Chapter 440, was enacted in 2001. This is important because 2001 was one of the most heavy periods of introductions of legislation because we were preparing to implement the EU acquis. The EU acquis is the set of laws that each and every member state must implement to be accepted as a member state. And data protection is seen as an important tool to ensure that the fundamental freedoms of the EU are implemented. The key dates in the implementation of GDPR. From the date that the Commission launched this proposal, 2012, to the date that the European Parliament, the Council, and the EC, the Commission, reached agreement, 4 years passed. And this shows that GDPR was quite controversial. And it was quite controversial, not because it introduced new principles from a data protection point of view, but it introduced a number of data subject rights which were heavily resisted by social media sites. So the first data protection instrument was a directive, And the GDPR, as the name suggests, is a regulation. So for the benefit of, for those of you who are not lawyers, the main difference between a regulation and a directive is that a directive needs member states to enact national laws to implement that legislation, whereas a regulation is directly enforceable. So it has direct effect even without national laws implementing the provisions of the regulation. Having said that, even though it's a regulation, some matters have been left at the discretion of the member states. Most of these matters have been left at the discretion of member states because the EU doesn't have competence in a number of areas, such as national security. Okay. In Malta, the authority dealing with data protection is the Office of the Information and Data Protection Commissioner. They are quite very knowledgeable and very receptive to answering queries. So whenever you have queries, I encourage you to get in touch with the Office of Information and Data Protection Commissioner. Some changes between the directive and the regulation. So in the past, when the directive was in effect, each controller, so each company or each person processing personal data, was required to register with the commissioner. And registration involved the completion of a notification form, whereas you notified the commissioner not only that you were processing personal data, but you had to indicate the processing activities that you were undertaking. In addition to that, you had also to pay a nominal annual fee to the Data Protection Commissioner. With the introduction of GDPR, both were scrapped. So there is no need to notify the Data Protection Commissioner, and there is no need to pay any annual fee. Okay, so as we said, the Data Protection Act in Malta was recently also repealed, so a new law, Chapter 586, repealed the previous Chapter 440, and there are also a series of regulations implementing or introducing country-specific laws. Okay? So, data protection principles. So this is very, very important. So the data GDPR, following up on the Data Protection Directive, sets out a number of principles. So the principles lie at the heart of GDPR, okay? So basically, even though they do not set up specific rules, they set the scene for everything that follows. So that they are seen as the fundamental blocks for good data protection practice. Okay, so what are these data protection principles? Okay, so this is not a mistake. So 7 and 8 are detached from the 6 data protection principles. So the first data protection principle is that data must be processed fairly and lawfully. Okay? The second data protection principle is that data must be processed for a specific and specified purpose. Okay? The third data protection principle is that data that is processed must be adequate to the needs of the controller. So if you do not need to process data, do not process it, because any data that you process in excess of what you need goes against the data protection principles. Closely tied to this, there is the fourth principle, that data must be accurate and kept up to date. Okay, so if you are processing data, okay, if you are storing data, there is the expectation that you must keep such data accurate and up to date. Okay, again, because this everything is a chain, there is the principle of storage limitation. Okay, in fact, I believe Kevin mentioned that he is one of the main reasons for subscribing for this course is to learn how to set out data retention periods. In fact, data retention period storage limitation is one of the fundamental principles of GDPR. The sixth fundamental principle is integrity and confidentiality. So there is the expectation, there is the requirement that any data that you store, any data that you keep is kept safe and confidential. And as we will see in further slides, there are severe penalties that come in play whenever there is a data breach. The seventh principle, the seventh concept, let's call it a concept introduced by GDPR, is the concept of accountability. So in everything that you do as a controller, you need to show that you are complying with GDPR. Okay, so during the course of the processing activities, the onus of proving compliance rests with you, rests with the controller. Okay, eighth concept, protection by design. So data protection must feature in each and every stage of data processing. So if you are and we have some IT professionals with us. So if you are devising a new IT system, you need to think about data protection in each and every stage before launching the app, before launching a process. Data protection must feature in each and every stage. Any questions till now, please? No. So, the territorial scope of GDPR, and this is one of the changes from the Data Protection Directive. So, of course, GDPR applies to all entities and persons based in the EU. So if you are a company or if you are a person based in the EU, GDPR applies irrespective where processing takes place. Okay? However, GDPR applies also in relation to non-EU entities if they process personal data of EU data subjects and they offer goods and services in the EU or they monitor behavior in the EU. Probably you have witnessed this when accessing certain sites based in the USA. There are a number of prominent sites based in the USA where they use geolocation to restrict EU nationals from accessing the websites, and they do so because they do not want to become subject to data protection, to the EU GDPR. Anyone witness this? Don't be shy, come on. Not yet, Rafael is saying. So there are a number of prominent, even newspapers, news portals, where they don't accept EU national, EU data subjects because they don't want to become subject to GDPR. So data protection deals with the processing of personal data. So the first thing that we're going to do is we are going to analyze in quite some detail what constitutes processing and personal data. So processing is defined as any operation or set of operations which is performed on personal data or on sets of personal data, whether or not by automated means such as collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available, alignment or combination, restriction, erasure, or destruction. So I would like to ask you, what do you think is the purpose of the terms which are underlined? What do you think is the aim of the legislator when choosing the terms that I underlined in the slide? What do you think he wanted to achieve by the terms underlined? Francesca, the lawyer, come on, you should know this.
Sorry, I think is as long as you use such as is not exhaustive list, so you open the door in case of the development of technologies and so on and so forth.
Exactly. So the legislator wanted to extend the definition as much as possible. So we have any, so it includes anything under the sun, whether or not by automated means, and we have also such as. So even though the legislator expressly outlined 8 or 9 different activities, the legislator did not want to restrict himself, and thus he included the qualifier such as. So this extends the definition considerably. Okay? If we go to the definition of personal data, the definition basically is divided into two. So the first part defines a data subject. Okay? So personal data is defined as any information relating to an unidentified or identifiable natural person. And then it defines what an identifiable natural person is. So an identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, identification number, location data, online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. Question for you guys. Do you think that data of a deceased person is considered to be personal data?
Sorry, would you please repeat the question, please?
So data of a deceased, a dead person. Do you think that that constitutes personal data?
I presume yes.
Someone says yes.
It's still referring to a natural person, and the person concerned is still identifiable. Actually is identified. So I would feel safe saying that yes.
Okay, and Alexander says yes, because a dead person still refers to a natural person. So the answer is no. So the GDPR data protection doesn't extend to deceased persons. However, it gives the discretion to member states to extend the application and the protection of personal data to the heirs of the deceased person. Member states such as, for example, Spain and Italy have decided to extend certain parameters, certain rules also to heirs of deceased persons. Malta as of yet, did not decide to do so. Marek is saying that Poland does so too. Thank you, Marek, for sharing. Okay. So after setting out the definition of personal data, there is a subset of personal data which is defined as special category of personal data. In the past, we used to call it sensitive data. So data constituting or showing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, health, or data concerning sex life or sexual orientation is deemed to be sensitive data and thus subject to an added level of protection, as we will see in further slides. Same applies to criminal convictions and data concerning children.
Can I ask a question, please?
Sure.
Okay, regarding personal data, does this extend also to possessions of a person, like, you know, if there's someone taking a photo and there's a car with a number plate, can the owner of the number plate complain that the person posting that photo is in breach of GDPR? Like,
can I answer you after the following slide?
Sure. Okay, because I wasn't sure. Okay, thanks.
Sure, no worries. So we have the first exercise for you guys. So we have 5 different items: Joseph Farrugia, high blood pressure, red Mercedes, salary and bonuses, and police conduct certificate. I would like you to identify out of these 5 which is personal data, which is sensitive data, and which is out of scope. If you can, I don't know, unmute. It's better if we discuss this viva voce.
I think red Mercedes is out of scope. High blood pressure might be sensitive data because it's related to the health, and personal data is the rest of it. This is my opinion.
Thank you, Rafael. And anyone else? So Julia is saying 3, 4, 5. What do you think 3, 4, 5 are, Julia? Anyone else? So Julia is saying 3, 4, 5, they are sensitive data. Kevin is saying 2, 4, 5 are sensitive. Okay. Anyone else? We have.
In my opinion, there is only high blood pressure as sensitive data. Red Mercedes, C, out of scope, and all the others personal data.
Okay.
I have doubts about salary and bonuses, whether it is sensitive data.
Okay.
Depends how much you earn.
That's why it's a bit.
Okay.
So
the purpose of the slide is to basically show you that you need to be inquisitive. You need to be analytical. What do I mean? If I tell you, I don't know, I go to a car website and I see a red Mercedes. So that on its own is not personal data. If, however, I have a database of an insurance company and I know that Joseph Farrugia has a red Mercedes, the fact that I have a red Mercedes becomes personal data because I can associate it with a person. Okay? Same applies for high blood pressure. So if I go to Wikipedia and I search for general information about what constitutes normal and high blood pressure, that is out of scope. However, if I know that Joseph Farrugia registered 140/60/70, that becomes sensitive data. Okay? Salary and bonuses, same applies. However, even though salary and bonuses is sensitive in the strict definition of the word, for the purposes of GDPR, it's not considered to be special category. Okay? So it is sensitive because it touches upon, some sensitive data, but it is not considered to be special category of personal data. Police conduct certificate, it's considered to be a special category on its own because it shows criminal convictions or the lack of criminal convictions of a person. Okay? And please be careful if you are dealing or working in HR. There is the practice in Malta, and I believe we have Jude working in HR, of requesting police conduct certificates prior to engagements. Okay? Be careful. We will see in later slides that is quite a sensitive area. Okay? Anyone wants to ask something? No? Okay. So, so we have two main actors, okay, in dealing with data protection. We have the controller and we have the processor, okay? It is fundamentally important that we learn to distinguish between the two. Failure to do so will mess up all your GDPR compliance. So if you think that you are acting in the capacity of a processor, where in fact you are a controller, will mess up all your GDPR compliance and will result in you being exposed to hefty penalties. Okay? So the controller is defined as the person, public authority, agency, or other body which alone or jointly with others determines the purposes and means of the processing of personal data. On the other hand, the processor is the person, public authority, agency, or body which processes personal data for and on behalf of the controller. Okay? In the following slides, we'll go into detail as to what constitutes a controller or a processor. Okay? So as we have seen, the first element is the type of actors. So just like the definition of personal data and processing, the legislator wanted to extend the definition of controller quite extensively. So it covers natural and legal persons, so companies and persons, public authorities, agencies, or other bodies. Okay, so again, the extension of the definition. Okay, the second element is determines. Okay, so the factual influence that the controller has over the processing operation. Okay, so there must be an exercise of decision-making power. Okay, so what must the controller determine? So what we need to ask is the how and the why. Okay, so the controller is the one deciding on the purpose, the why, and on the means, the how. Okay, so these are the things that you need to ask, the how and the why. Okay, so it's a very pragmatic approach. So more often than not, cases might not be clear, so you need to dig quite deeply so as to determine whether we are speaking about controller or a processor. Another layer of complication is that the how and the why need to be assessed in relation to essential and non-essential elements of processing. Okay, so essential elements means the type of data to be processed, the period for which they would be retained, the data subject from whom the data will be collected, who will have access to data, the recipients of data, etc. So these are usually elements that are reserved to the controller. On the other hand, non-essential elements such as the software to be used or the technical security measures might be left in the hands of a processor. Okay? So when you ask the how and the why, distinguish between essential and non-essential elements. Okay? Okay? So I have prepared a high-level checklist of elements that usually point out that you are acting as a controller. Okay? So you have decided to process personal data or caused another entity to process it. You decided what purposes or outcome the processing operations needs to have. You decided on the essential elements of the processing operations. The data subject of your processing operations are your employees. You exercise professional judgment in the processing of the personal data. You have a direct relationship with the data subject. You have autonomy and independence as to how data is processed. You have appointed a processor to carry out processing on your behalf. So if in the analysis of a particular processing activity, you point out, you identify one or more of these elements, the likelihood is that you are a controller. Okay? What constitutes a processor? Okay? So again, the definition is defined into two. Just like controller, the first part is defining the type. So it's, again, a natural legal person, public authority, agency, or other body processing personal data on behalf of a controller. Okay? So the processor is serving the controller interest in carrying out a specific task. And it is following the instructions set out by the controller. Okay? So as we have seen in the previous slides, the purpose and essential elements are set out by the controller. Okay? Something else to keep in mind is that a processor need not be a subordinate. Okay? It can still enjoy a considerable degree of autonomy. Okay? Okay? Very, very important. So if you are a processor and you exceed the mandate, so you exceed the parameters set out by a controller, you become a controller yourself. Okay? And it's by becoming a controller yourself, you subject yourself to penalties and to the principles and obligations of GDPR. Okay? Okay, and again, the high-level checklist. You are a processor if you follow instructions from another party. You do not decide to collect personal data from individuals. You do not decide on the legal basis. You do not decide the purpose or purposes for which the data will be used. you do not decide the data retention period, and ultimately you are not interested in the end result of the processing. Okay? Any questions?
So if I decide on a particular retention period, I become the controller?
If you decide on the data retention period, most likely you are acting as a controller. Why am I saying so? Because if you are a processor, you are processing data for and on behalf of a controller. And one of the requirements when acting as a processor is that you must delete the data when your engagement finishes. So if I engage you to do the payroll on my behalf, one of the conditions that I set in the agreement that we execute between us, so between a controller and a processor, is that as soon as your engagement finishes, you must delete the data that I give you or the data that you generate on my behalf. So this is why if you determine the data retention period, the likelihood is that you are acting not as a processor, but as a controller. Okay, Kevin?
Thanks.
Okay. Anyone else? Any further questions? Okay.
Sorry, just one question. Just one, for example, if you will look at the UK, do you have any decision by officer saying, clearly distinguishing, looking at the practical case, like we could go through on our own, like having a kind of practical readings?
Yes. In the following slides, in fact, Raffaele, we have a number of examples, a number of case studies.
Okay, yes, case study, jurisprudence, domestically applied, and so on and so forth. Yes,
sure. Yes, definitely. In the following slides, there are a number of case studies so that we can discuss them together for me to understand that you grasped the distinction between the different actors.
Exactly. This is my thinking, because having a legal background as well, so just I was wondering this.
No worries, Raffaele.
Thanks.
We'll do that. So to add a further layer of complication, there might be circumstances where two or more actors are acting as joint controllers, okay? And this happens where two or more controllers jointly determine the purposes and means of the processing, okay? When this happens, the first obligation is to define the responsibilities for compliance with data protection obligations. In fact, whenever there is joint controllership, there must be specific arrangement laying down the roles and responsibilities, in particular towards the data subjects. And in fact, for the benefit of Francesca is the lawyer, right? Whenever you encounter a situation of joint controllership, be very, very careful, because this generates a number of pitfalls, a number of very, very serious issues that you must address in agreements. The agreement that you have to execute whenever you have controller to controller, joint controllership relationship is very, very detailed. So be very fair whenever you encounter a situation of joint controllership. Be very, very careful and ensure that the responsibilities between controller A and controller B are outlined in detail in the agreement. Okay? And in order to respect the principle of transparency, the arrangement between the joint controller must be disclosed to the data subject. So you must disclose that you are acting as joint controller and summarize the arrangement between the parties. Okay. Julia is asking, does it mean that joint controllers have joint liability? Let's say in case of breach by one of controller. It depends, Julia. This is why the responsibilities must be outlined, must be set in the agreement, in the absence of which, yes, there is joint and several liability. Okay?
Sorry, pardon. As regards this joint liability, are we talking about liability in solidum between the two? Okay.
Yes.
Thanks.
Okay. Case studies. So I chose 2 case studies of travel agencies. I know it's painful in the COVID age, this is speaking about travel agencies, but this should explain the distinction between the different actors. So case study 1, a travel agency sends personal data of its customers to the airlines and a chain of hotels with a view to making reservation for a travel package. The airline and the hotel confirm the availability of the seats and the rooms requested. The travel agency issues the travel document and vouchers for its customers. What do you think in this case? So we are speaking about the travel agency, the airline, and the hotel. Can you identify whether these are acting as controller, processor, joint controller? Sarah, what do you think?
I think it could depend, because if the airline is sending data directly to the hotel, if the travel agency is sending the data to the airline or the hotel, they may not need to keep the data, so they could be, they may not need to keep it. However, they also take bookings on their own, so surely that would make them a controller as they're taking bookings and would need to have their own procedures in place.
Okay, valid points. Keep in mind what we said before. So the determining factor is the party determining the how and the why, okay, of the purposes of the processing. So Julia is saying in chat, as long as the hotel and the airline does not require additional information, they would be considered as processor. Okay, valid point. Now we'll discuss. Francesca, what do you think?
I think that in the first scenario, there isn't joint controllership, since it seems that the travel agency is the one which is taking the decision and determining the means and the reasons why there is data processing.
But what about the airlines and the hotels? What are they doing in this case?
They are responding to the travel agency's requirements.
Okay, fair enough.
For example, I'm seeing the second case scenario. For example, there's an agreement between the two.
But let's focus on the first.
Yes. Okay. To show the distinction.
But what's crucial and what I want to point out is that the airline and the hotel themselves, they determine the means and the purposes. So the airline and the hotel, because of legal requirements, they determine what data do they need in order to process the booking. Okay, so in that case, we have 3 separate controllers. Okay? We do not have a controller to processor relationship. And the determining factor, it's because the airline determines what data it needs to be able to book a seat. Same applies for the hotel. And in fact, the airline, the hotel themselves individually have legal requirements to comply with in order to ensure that they keep records even for security purposes. Okay, so understood the distinction, and then understood why it's important to ask this question, the purposes, the how and the why. Perfect. So let's go to the second example. So building on the first scenario, we have the same travel agency, hotel chain, and airline. But in this case, they decide to join together and set up an internet-based common platform in order to improve their cooperation with regard to travel reservation management. They agree on important elements of the means to be used, such as which data will be stored, how reservations will be allocated and confirmed, and who can access to the information stored. Furthermore, they decide to share the data in order to carry out joint marketing activities. What do you think in this case, guys? Maybe we can ask Joseph. Joseph, what do you think in this case?
I think because they all joined together, they would be joint controllers.
Okay. Anais, what do you think in this scenario? The actors, in which capacity they would be acting? Okay, can you type, Anais? No worries, no need to use your mic. Okay, so in the meantime, Anais is logging off and logging in again. Alexander, what do you think in this scenario? Okay, Kevin is saying that they all carry the same responsibilities. So the determining factor, so you got it right. So these are joint controllers. The determining factor is that they have jointly determined the means to be used. Okay, the means and the purposes. So in that way, they render themselves joint controllers. Okay. So another question that I wanted to ask. Let's take another scenario. Okay, so let's take a scenario of a typical company. So there is a CEO sharing data of an employee with the HR executive. In that case, what actors would we have? Okay, so we have the CEO in a company sharing data of an employee with an HR executive. Raffaele, what do you think in this case?
They do belong to the same company, right?
Yes.
Events correct. So, well, in this case, they're just transferring the knowledge of data for purposes of the HR. So we do not have a relationship between controller and processors itself. We have something inside the company.
Jude, what do you think? Jude, you used to work in HR, I believe. In this case, what do you think?
Since I think he's already an employee of the organization, I don't think sort of the CEO. But how did they end up at the CEO in the first place? I mean, was from outside, or is it because normally
so it's internal data of one of the company's own employees.
I think the HR officer needs to have the responsibility for that data. Obviously, the process, how it is processing it, and the CEO then is, I wouldn't be able to answer, to be honest. I have doubts about it. How
But
if
do
he's
you think that
responsible?
this scenario results in a controller to processor relationship?
No, I don't think so.
Very good. So in this case, we don't have a transfer of data. Okay, data was transferred within the same organization, within the same perimeter. So data, there is no controller to processor, there is no transfer of data for the purposes of GDPR. Okay? Very good. Most of you got it right.
If I may ask about
Sure.
this example. So if like the CEO is discussing health issues of this employee, would he be in breach to discuss these matters since it's sensitive data?
The answer to this question depends on what he's doing with what questions he is asking, what he's doing with data. Keep in mind that as employers, there is one of the fundamental duties of employers is to make sure that they ensure that employees are healthy. You know, they provide a healthy environment. So if they're processing data in order to ensure a healthy environment, then it's a legitimate interest to process that data. So he wouldn't be in breach of GDPR. So it depends what he's doing with the data.
That is my question, because I mean the fact that he's a CEO doesn't mean he has the right to ask for sensitive information. Like, I think
it depends what he's doing.
Right, I guess not.
There is no yes or no answer in this case. What you need to ask is, why is the CEO asking about health information of an employee? Does he need to access it?
That's what I mean. That's right.
Yeah. Upon which ground is asking those data?
Exactly. So if he's asking that information because the company is carrying out an assessment, for example, recently, most companies introduced remote working methods. Okay, so if the company is now assessing whether to return back to an office environment, and they are carrying out a risk assessment, and there is an employee who suffers from, I don't know, asthma, and the HR executive points out this to the CEO so that a decision is taken, I don't consider that to be in breach of GDPR. So you need to dig deeper when asking these questions. So there might be a reason for the CEO to take a decision based on the health of one of the employees. Okay, do you agree with my assessment?
Yes, definitely. It might be that there is some provision in employment law which impose to do something like that, or some decision from the health authority.
And I try to give a practical example, which we are being asked to advise on currently. You know, companies are considering whether to get back to normal working environments. So in addition to GDPR, they are carrying out health and risk assessments. Okay, so in order to carry out a risk assessment as to consider whether the work environment is safe, you need to process certain health or medical data, especially if you have certain vulnerable employees. So in that case, there is a legitimate interest, there is a purpose as to why an employer or a CEO or an HR executive is processing sensitive data.
So, sorry, speaking about sensitive data and the remote working, let's consider, for example, that one employee tests positive from the COVID. So this is, my knowledge is quite highly sensitive personal data. The other employees, all right, if they were still in the same premises, they turn up to know that the guy was tested positive, right? Because it's going to be the contact tracing. How would you handle this kind of situation from purely GDPR perspective?
Okay, so what you need to do is you need to weigh the different interests. So one of the fundamental principles, of course, is the privacy of the individual. Okay, so the employee who tested positive, there is a legitimate expectation that one respects his privacy and does not disclose that he is positive. Okay, but you also need to weigh the interests of the company and the other employees. Okay, because as an employer, I have a requirement, I have a duty to ensure the health and safety of the other employees, okay? As well as ensuring that I provide a safe environment. So if I weigh the two interests, so if what you are saying, by showing or by disclosing that employee A is positive, I breach his privacy. However, by breaching his privacy, in inverted commas, I am ensuring that the other employees are safe. I am ensuring that I provide a safe environment. So you need to weigh the interests of both parties. Okay, you need to carry out a risk assessment. Did I answer your question, Raffaele?
Yes. So it's like a balancing of the interests at stake and the rights of the people.
Yes.
And also the safety as a company as its own.
Yes. So if, for example, if we take the normal scenario of an employee being sick, okay, I wouldn't disclose that he is sick, okay? But if in the COVID example, let's assume that he is sick whilst at work, I need to disclose that employee A was positive because I need to inform the other employees that they might be positive as well. So this is why you need to carry out this balancing of interests.
I see. And what about if the person was already working remotely and it turns out to be positive? So there was no contact anyhow with the other employees.
There is no need to inform the other employees.
Exactly. So based on the risk assessment approach that you were saying.
Based on the balancing between the different interests of different actors.
Exactly.
Okay? In this case, the right of privacy of the individual wins. Okay, it outweighs the other rights.
Clear.
Perfect. Okay, so the controller is subject to a number of duties as per GDPR. Okay, so the first duty is adherence to the data protection principles that we mentioned in the first slide, and to ensure that he is accountable for compliance and to demonstrate compliance in each and every step. In addition to this, okay, so let's skip this. In order to comply with the principle of transparency, the controller is required to provide clear and accessible information about the processing, to respect the data subject rights, and to ensure that data subjects can exercise the data subject rights easily and at any moment in time, okay? If you fail to do that, you subject yourself to substantial fines. On the other hand, the processor is only required to process personal data on the documented instructions of the controller and doesn't exceed the parameters set out in this agreement. Okay, so the obligations of the processor when compared with the controller are definitely lower. Okay, so this is why in the beginning I made it a point to point out that it is fundamentally important that you determine whether you are acting as a controller or as a processor. Okay, because if you get this wrong, you wouldn't identify the duties that you must respect. Okay. Another case study. Company outsources some of its operation to a call center and instructs the call center to present itself using the identity of the company when calling the company's clients. What do you think in this case?
All right. I do believe that the company is obviously the controller, right? He has the ultimate responsibility, and it's outsourcing to a call center. But I'm not quite sure about its instructions of selling themselves as coming from the company towards third parties, which are the clients.
Okay, valid points. Francesca is saying that the company is a controller and the call center is the processor. Joanna, what do you think? Same. Okay, yes, agreed. The company is the controller and it's engaging the call center to act on its behalf. Okay, so in that case, I believe is, yes, Julia, the key word I believe is instructs. Yes, it is giving clear parameters as to how the call center should be acting. Case study number 2, a company provides software to process the attendance of teachers in a school. Using the software, the company gives attendance reports to the school. The company's sole purpose in processing the attendance data is to provide the service to the school. The school sets the purpose to assess attendance. The company has no need to retain the data after it has produced the report. It does not determine the purposes, it merely provides processing services. In this case, what do you think? There are a number of hints in the actual case study itself in order to help you make this assessment. Kevin is saying processor. Who is the processor, Kevin, in this case? Okay, Kevin is saying that the company is the processor. Joanna is agreeing. Sarah, what do you think?
Yeah, I agree as well.
Perfect. Okay. Yes. Agreed. And there are a number of hints, indicators. So the school says the purpose, so it determines the means, the how and the why. And the company has no need to retain the data. It just provides the service, and that is it. Okay. Okay, perfect. Again, this is another example, but in this case, we are using a diagram and we're showing the 3 main actors: employee, data subject, employer, controller. If the employer engages a third party to help it with payroll, that third party is a processor. Okay? As we said in one of the previous slides, one of the requirements when a controller engages a processor is that it has to make sure that the agreement is in place. And the elements that must be included in this agreement are outlined in the GDPR, so are determined in the GDPR. So the contents of the agreement must be the following. So the agreement must expressly stipulate that the processor must only process data on documented instructions by the controller, okay? In addition to this, if the processor is using employees to process the data under this scenario, it must ensure that such employees are committed to a duty of confidentiality, okay? It must also take measures at ensuring security of processing, okay? And I would add here also to respect the principle of accountability, that you do not stop here. You do not stop just by saying that the processor must ensure security of processing. Ask what measures will the processor be implementing, okay? Be proactive, because if something happens and there is a data breach, you must show that you prior to engaging a processor, you did your due diligence. So ask what measures the processor will be implementing to ensure data security, okay? You must also stipulate that the processor wouldn't be able to appoint another sub-processor without authorization of a controller, okay? The processor must also commit to assist the controller to respond to data subject requests. Important, the processor is not authorized to respond directly to a data subject request. So if we have this previous scenario, this scenario, okay, we have an employee, we have a controller, and we have a processor, and the employee lodges a subject access request. So it requests what information the employer has on him, okay? Even if the third party is processing data on behalf of the controller. So even though the system, so the third party processor here has data of the employee, the employee cannot request data directly from the processor, okay? Very, very important. So if the processor discloses data directly to the employee, he is breaching GDPR, okay? Another requirement that must be included in the processor agreement is must be a commitment to assist the controller for data protection impact assessment and in data breach notifications. So if the processor has a data breach, he must inform immediately the controller, okay? And as we said previously, I believe in the discussion that I had with Kevin, and at the end of the engagement, the processor must either delete or return the data which has been either provided to him or generated in the course of the processing activities. Any questions before we start the next?
Okay, I'd like to put a question. So let's say you have like a supermarket with a loyalty scheme, and they want to print like some information, some offers for their clients. Mm-hmm. In this case, for the supermarket to ask the printer to print, I mean, on this media, like the addresses of their customers through the loyalty scheme, do they have to make a formal agreement, like, or is it can be done via an email only? Like, you know, the fact that they have to, the printer has to print this information.
Very good question. No, I wouldn't take risks. At the end of the day, especially if we are speaking about names and addresses, and not just, for example, just an address, I would make sure that the supermarket executes a controller and processor agreement with the printer, because ultimately the printer is accessing and is processing personal data. I wouldn't take risks.
Correct. So, like, if I am in a loyalty scheme, can I ask, for example, I know I'm being a bit difficult, but I mean, I don't know, can I ask the supermarket to show me like this type of agreement that he sort of set up with this printer so that I ensure that my information wasn't...
When you say you are speaking about a data subject?
Yes, and I am in a loyalty scheme at a supermarket.
Okay.
And I received like printed information with my address. So it's not like the occupier, it would be enough Mr. Amy and the address, whatever. So I have a right to ask the supermarket to show me like an agreement that he set up with his printer.
You have the right to submit a subject access request. And if you have a legitimate reason to ask for it, you can also ask the recipients that the supermarket shared your data with. So the short answer is yes, you can ask for the supermarket to identify how he got your data and with whom he shared your data.
Okay.
Just to close this parameter, keep in mind that in Malta, your data might be accessible in through different methods. There is the phone records, okay. There is the electoral register. So keep in mind that, okay. Keep in mind that the supermarket might have got your details from these sources.
Dr. Sammut,
when he keep this information without my permission, let's say he accessed the information through the electoral register, which was quite common in the past. I don't know.
Very good. This is why I made this point, so that you ask this question.
Yeah, that's right. Would he the fact that he got it through a formal channel? Like, I don't think it's available anymore, but in the past I remember buying this information. Would still the supermarket have to explain why he's keeping this information without asking you, even though he got it through another channel?
Exactly. So what you need to ask is, what is the purpose of Malta publishing the electoral register? It's definitely not to help the supermarket in its marketing activities.
That's right.
So if the supermarket obtained your details through this method, it might be breaching your personal data, your right to privacy. Okay? I believe there was another question.
I think it's a simple type, but I don't like to assume. As employees, I think they have, or data subjects, I think they have every right to know, obviously, the third party who would be processing, for example, the payroll. If it's, for example, the company is outsourcing payroll, like we said before, and the employee asks the company who is processing the payroll. I think the company obviously has every duty to say to the employee that company is processing your payroll.
Yes, perfect. Keep in mind that in the beginning we outlined the data protection principles, okay, which must be observed at all time. And we said that the data protection principles lays the fundamental principles on which the specific rules are built. And one of the fundamental principles is the principle of transparency. Okay? So in order to process data in line with GDPR, you need to be transparent with the data subject. And in practical terms, this means that the employer must have a privacy policy in place. And the privacy policy must disclose, one of the items that must be included in a privacy policy, who has access to the personal data being generated. Okay? So if they don't identify in the privacy policy that the data of the employee is shared with a third party to process payroll, and ideally also identify the name of the payroll agency, then they would be in breach of the transparency principle, and as such, in breach of data protection.
I believe it's important only, I think, not to disclose any names, of course, of the third parties, employees, or things like that, I imagine.
No. So in order to, let's take the same example. In order for the company to process payroll, okay, it must disclose also the names of the employees as well as the wages, okay? But in order to transfer the data to this third party, okay, and in order to observe and comply with the transparency principle, prior to disclosing the data to the third party processor, okay, and in addition to this agreement, there must also be a data protection privacy policy, okay? And one of the items in the privacy policy, okay, with the employees, you must inform the employees that you are sharing data with a third party. Okay?
All right, okay.
If you don't do that, you would be in breach of the transparency principle.
All right, okay, fair enough.
Okay, Francesca is asking, how do you determine legitimate interest for the purposes of GDPR, considering that it is not expressly defined? Francesca, the last hour or so of this presentation is on legitimate interest, so we'll have time to discuss this. Okay. So I believe it's a good time to stop for 5 minutes before starting legal round. So let's reconvene in 5 minutes. Okay, guys. Hello, we're back. Just make sure that everyone is back. It's very, very sad speaking to a screen and no interaction, but I believe it's the new reality. So I have to make do. So everyone is back. Show me your live, please. Chat. Okay. Okay. So let's continue. So let me start by asking a general question. Let's ask Sarah. Sarah, can you hear me? Sarah?
Yeah, sorry.
No worries. Sarah, so if I had to ask you this question, how would you reply? So if a data subject gives his consent, does that mean that you can process his data? How would you answer this question? So if I'm a company, okay, and my employee gave me his consent or her consent, does that mean that I am fine as a company and that I can process his data? How would you answer that question?
Would it depend on consent for what data, and surely it would have to be outlined?
Let's say that we told him that we're gonna process his data so that we can assess whether he is fit for a promotion or not. Okay? And he gave his consent. Would that mean that I am fine as a company?
And how did you get the consent? So was it electronically? Was it verbally?
Let's say that he signed a document, so there is definitely no doubt that he gave his consent. I told him that I'm going to process the data for purpose A, he agreed with it, and he signed a document.
I think as long as you keep within the grounds of that agreement, then yes.
Okay. Joanna, what do you think? Joanna, are you with us? Doesn't seem to be the case. So
I don't think that the consent only is enough. I think there should be the legal basis or another grounds to process such request.
Okay, very good. What if I ask the question in inverse? Okay, the inverse of this question. Can I process the data if I don't have consent? What do you think, Kevin?
I don't think you can in that case.
Okay, so if you think that if I do not have consent, I am not able to process.
But process as a company?
As a company, yes. No worries.
As a company, on your employees, I think you can.
So, okay. Marek, what do you think? I don't have consent. Can I process personal data?
To be honest, I don't really get the whole question, because can you repeat it in whole the question?
No worries. So what I'm asking is, let's take any scenario that you can think of. Let's take a company processing data of the employee, okay, in order to process for any reason whatsoever, okay? Let's not get into detail. the company did not obtain the consent of the employee, okay, to process that data. Can the company process that data without consent?
I would say no, but then there is the question about the employee contract, if there is any clause including it or not, I'd say.
Okay.
Sorry,
Very
can I
good.
add, is it a yes
Sure.
because it says if based on one of the following basis? So consent is one of the basis, but there's also other factors. So
Very
you
good.
don't have consent, but there's legitimate interest, then yes, you can.
Very good, very good. So let me build on what Sarah just said. And in fact, I wanted to use this as an introduction because these two scenarios, these two questions, are two of the most common mistakes that we encounter in the course of our work. Okay, whenever we're doing data protection audits, more often than not, companies think that if they have consent, they have carte blanche, they can do whatever they want. Okay, as we will see, it is not the case. So first and foremost, consent is only one of a number of legal bases on which one is authorized to process personal data. So there are circumstances that even without consent, you would be able to process personal data. Okay. So how is consent defined? So consent is defined as any freely given, specific, informed, and ambiguous indication of the data subject wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. In the following slides, we will dissect this definition and analyze each and every element of this definition. So what constitutes freely given? So basically it means giving a real choice and control to the data subject. Choice would not be deemed to be free if the data subject is unable to refuse or withdraw consent without detriment. Okay? Case study for us to discuss. A mobile app for photo editing asks its users to have their GPS localization activated for the use of its services. The app also tells its users it will use the collected data for behavioral advertising purposes. Neither geolocalization or behavioral advertising are necessary for the provision of photo editing service and go beyond the delivery of the core service provided. What do you think about this scenario? What if the user gives his consent? Do you think it's freely given?
So I think it's not freely given because you are forcing someone to give consent to something which is not necessary for the core service.
Exactly, yes. So those are the key points.
And
so,
it's not limited to the purpose limitation.
Exactly, again, yes, also a valid point. And no one else to point out another important element?
Also, we may underline that, stress that the consent is one of the legal bases by which you give, as a company, you give a total ownership to the client, to the data subject. So you could withdraw at any point in time.
Okay.
So unless you cannot play on other grounds, you cannot go. In theory, you could not go ahead with the processing.
Okay, another valid point. But in addition to what we said, what you said, another important element that results in this scenario and in this consent not being considered as valid is because of the detriment. Okay, because if I don't give consent, the photo editing service does not work. Okay, so what we're saying is that the geolocalization is not required for the provision of the service. However, if I don't give consent, the app doesn't work. Okay? In this case, there is detriment, and as a result of this detriment, it means that consent is not considered to be freely given. Okay. Imbalance of power. So consent would not be considered to be valid in those situations where the data subject will be compelled to accept the terms of the processing set by the controller. So in the circumstances, in those events, in those situations where I, as a data subject, have no alternative, I have to accept, otherwise I face consequences. Okay? One of the logical examples is in the case of public authorities. There is a clear imbalance of power between authorities and citizens. Okay? There is no realistic alternative but to accept. So whenever public authorities are processing data, consent, the likelihood, more often than not, is not a valid legal basis. So they must base their processing on another legal basis. Okay? Hope that I will not be shocking you, but in an employment context, consent 99.9% is not a valid legal basis. So all the clauses in contractual agreements, in employment contracts, that I, as employee, give my consent to the processing of etc., etc., they are a waste of space, a waste of clauses. Why? Because there is a clear imbalance of power between the employer and the employee. Okay? The employee would not be considered to have a free choice whether to consent or not. Understood? Please tell me that you understood this point, because this is one of the most common mistakes that we see and we encounter. Okay? Employers basing their processing solely and exclusively on the fact that they obtained consent from their employees. Okay? And I assume that you understood. The rule is not absolute, however. There are a number of small, limited circumstances where you are able to obtain consent from an employee, and that would be considered to be valid. Okay? We have three different scenarios. Scenario one, employee is asked to give consent to CCTV monitoring. What do you think? Is it a valid legal basis or not? Julia, what do you think? If James is recording you. Julia is thinking. Anyone else? Feel free to unmute and discuss, please.
I think yes.
I think, well, in my experience, I've seen CCTV notice clarifying that they were recording images for purposes of enforcement of law.
Okay, let's talk about the scenario of employees being monitored. Okay.
Yeah, I think you should, in the notice, right at the beginning of the premises, wherever the recording starts, you should give some information to the person who is recorded, including the legal basis upon which you are recording, which is not necessarily the consent. Could be, as I said, for example, enforcement of law or public order, as long as it makes sense.
Okay. Anyone else would like to add to what Rafael is saying? Joanna is saying that you cannot, for example, put a camera directly on a work desk. Fair enough, that's good practice, and that is because one of the principles that we mentioned is that you should not process data more than necessary, okay? So let's answer this question. So I ask my employees to give consent to monitor them by means of CCTV. Is that consent valid on the basis of what we're saying, the imbalance of power?
In my opinion, it wouldn't be valid.
Why, Marek?
Because there is an imbalance of power in this case.
Exactly. The employee would not be considered to give his consent freely, because at the end of the day, what happens if he doesn't consent? Would he risk facing disciplinary action? Okay, so because of this imbalance of power, consent, even if obtained, wouldn't be considered to be valid. Okay, so if you are basing the fact that you are processing and recording CCTV footage on consent, that is not valid. Okay, let's jump to scenario number 3.
But is there any valid reason to CCTV the office?
Yes.
I've seen it in so many offices around Malta, so that there must be a reason why they do it.
Of course. So as we will see further on, we can base it on other legal bases, such as the legitimate interest. Okay, and we will see, we'll use this example to carry out a legitimate interest assessment as to whether we would be entitled to monitor employees on the basis of my legitimate interest as an employer. Joanna is asking if CCTV, yes, exactly. Joanna, we will discuss this in further slides in relation to legitimate interests. Okay?
Sorry, may I just add as regard example 1?
Sure.
Let's suppose I am an employer and for some reason I want to collect the consent from my employees for the CCTV monitoring. It's not only, I think, invalid, but could be also impractical, not very practical. What happens if the employee one day, he give me the consent, right? And then one day he wants to withdraw the consent. It may cause problems.
Yes.
What do you think?
Yes. So that is a practical issue. But even if you got consent, you would still need an additional legal basis which justifies why you are processing that and collecting CCTV footage. Okay.
So even if you get the consent, will not suffice. You will still need something else.
Yes.
Okay. Okay.
So in the case of banks monitoring their cashiers, would that be a legal basis to see that they are not stealing any money or something?
Yep. We'll see this. We'll use this example. Kevin, I believe, right?
Yes.
When we are assessing the legitimate interest legal basis, okay? A very good example, so CCTV footage of a cashier, okay?
All right.
Okay, so Anais is saying that okay, Anais, so you can still follow, okay? Scenario number 3, employee is asked to give consent to feature in a filming of a social event. It is made clear that consent is totally voluntary and that they can opt out without consequence. So in that case, what do you think? Would consent be valid in this case?
Yes.
And why, Jude? Do you think so?
I mean, the employee has it's made clear this is voluntary. And the employee, there's no imbalance of power. I mean, it's the employee's choice at the end of the day.
Two things to keep in mind in this case. 2 determining elements. Voluntary, totally voluntary, and no detriment. Okay, so if he decides that he does not want to feature, nothing happens, okay? So no disciplinary action, nothing whatsoever. Okay? So in this case, two elements subsist, it's totally voluntary, and no detriment. So in this case, the employer would be able to base the recording of the social event on the basis of consent. So no additional legal basis are required. Okay, so another very important element in consent, conditionality. Okay, so allow me to quote, please, this provision. So Article 7.4 of GDPR states as follows: when assessing whether consent is freely given, utmost account shall be taken of whether, inter alia, the performance of a contract, including the provision of a service, is conditional on consent to the processing of personal data that it is not necessary for the performance of that contract. Okay? And I believe that we can use the following slides to explain in further detail as to what that translates in practical terms. Okay? So, things to avoid in getting consent. So, bundling consent with acceptance of terms and conditions, or tying the provision of a contract to a request for consent are considered to be not good practice and will result in consent not considered to be freely given. So now we'll explain in practical terms what we mean by bundling and tying. Okay? So bundling means bundling the consent with acceptance of terms and conditions. Okay? We see this regularly in internet scene. So more often than not, sometimes, let's say sometimes, so not to be drastic. Whenever you create a new account, before creating a new account, you are asked two things: to accept terms and conditions, and also to accept the privacy policy. Okay? If you bundle them together, okay, that is considered to be invalid. Okay, not good practice. Okay? Same with respect to tying. Okay? If you tie the provision of a contract or a service to a request for consent, that will be considered to be to result in the consent not considered to be freely given. So the two lawful bases, consent and contract, cannot be merged and blurred. Okay? So in order to understand this, let's take this scenario, this case study. A bank asks customers for consent to allow third parties to use their payment details for direct marketing purposes. The processing activity is not necessary for the performance of the contract and the delivery of ordinary banking services. If the customer's refusal to consent to these processing purposes would lead to the denial of service, let's rephrase. The customer's refusal to consent to the processing purpose would lead to the denial of banking services, closure of the bank account, or, depending on the case, an increase of the fee. So in that case, because of this tying, conditionality, and detriment, consent would be considered not to be freely given. Okay? Next slide. So I took this straight from Sainsbury's site. So keeping in mind what we just said about tying bundling, and conditionality. Do you think that this is valid or invalid? This is a practical example. Do you think that Sainsbury is respecting good practice in relation to conditionality, tying, and bundling or not?
In these instances, if you don't agree, you will not get the service. So I think they are not to be considered as binding.
Okay, but you are creating an account here, so it precedes you creating the account. Okay, so what we are saying here is that in getting consent so that you can create your account, is Sainsbury respecting the principles of conditionality, bundling, and tying? Keep in mind what we said. Bundling and tying you must ensure that you don't blur the acceptance of the terms and conditions with privacy policy or consent for the processing of personal data.
Yes, they are separate in this case.
So what do you think, Francesca, in this case? Do you think it's valid? Francesca is saying there is no option. Granted, Francesca, but here we are saying that this precedes you creating an account. So the option is discretionary in the sense that you must choose whether to create an account or not. What we're saying here is you must ensure that in order to respect the no tying, no bundling principle, the acceptance of the terms and conditions and the acceptance in this case of the direct marketing permission is distinct. So I can accept terms and conditions, but not accept that they contact me with direct marketing messages. So this is one of the perfect examples of how to distinguish between the two. Okay? Understood, guys? This is very, very important. So what we're saying here in this case, Sainsbury's, rightly so, understood that direct marketing consent should be distinct from the acceptance of the terms and conditions, and thus gave the data subject full liberty, full control whether to accept or receive direct marketing activity messages or not. So it did not bundle them or tie them together. Okay, so this is, if you follow this, it's 100% good practice. Okay, another fancy requirement is granularity. So what does this fancy word mean? It means that if in the course of giving a service, you have multiple processing operations, so you are processing operations for more than one purpose, you must distinguish between each and every purpose. Okay? So consent is presumed not to be freely given if the system does not allow data subject to give separate consent for the different purposes. So when data processing is done for different purposes, the system, the IT system, must separate between each and every purpose. Okay? another practical example which we took directly from the internet. Do you think that this respects the principle and the requirement of granularity? Okay, we have Jude and Alexander saying yes. Okay. Yes, again, this is good practice. It divided the different purposes into different sections, and it sought consent from the data subject on each and every aspect. Okay, so that follows 100% the principle of granularity. Okay, we've already touched upon this. So in order for consent to be valid, the controller needs to demonstrate that it is possible to refuse or withdraw consent without detriment. Okay? Let's just assess scenario 2, okay? Because we're running out of time. Scenario 2, a data subject subscribes to a fashion retailer's newsletter with general discounts. The retailer asks the data subject for consent to collect more data on shopping preferences to tailor the offers on the basis of the shopping history that is voluntary to fill out. When the data subject later revokes consent, he will only receive the non-personalized discounts. In that case, what do you think? Do you think that there is detriment? Do you think that there is detriment to such an extent that it would result in consent not being considered as not being validly given? What do you think? Rafael, what do you think?
Sorry, can you remake the question, please?
Okay, so we have, in simple terms, we have an online shop, okay? An online fashion shop, so a clothes shop, okay? And it asks for your consent to send you tailored marketing, tailored offers, okay? On the basis of your shopping habits, okay? So if you like to shop for Hugo Boss, for example, eventually it will start sending you special offers of Hugo Boss clothes. Later on, you withdraw your consent. So you will no longer receive such specialized, tailored marketing and special offers. Do you think that in that case, you face detriment?
Yes, because once I choose to revoke my consent, I do not gain access to any more to some discounts. So in fact, I do suffer a detriment because of my choice to revoke the consent. So the consent eventually is not given freely from any detrimental consequence in the case
what if you keep receiving the non-personalized special offers? So the special offers that this company, this shop, this online shop sends to everyone. In that case, so you will not be receiving the special offers based on your personal shopping habits, but you keep receiving the special offers that are sent to the users in general. In that case, do you think that you still face detriment?
I do not think so. I do not face in this case detriment because I chose to revoke the consent, and because of that, I do not have any more customized discounts. But it's quite, I don't know, it's quite confusing.
Exactly, Alexander agrees with you. Yes, correct answer. So it is not considered to be detrimental because it was an added service. So I gave my consent to receive the special offer, based on my shopping habits. And by withdrawing my consent, I only, the effect is that I will no longer receive such personalized special offers. So in all effect, no detriment was faced by the data subject. He voluntarily withdrew consent, and he knew that by withdrawing consent, he would no longer receive such specialized offers. Okay,
clear.
So Yulia is asking this question. What if such limit is due to technical capacity and the company is able to provide extended services only if the accelerometer... Oh, okay, so Yulia is speaking about the first example, okay?
So
yes.
in the case of the first example, does it has a detrimental effect?
Yes. So in the first example, let's also analyze the first example. So again, we have a lifestyle mobile app. The app asks for consent to access the phone's accelerometer. Okay, this is not necessary for the app to work, but it is used by the app company because it wants to learn more about the movements and activity level of its users. Okay, when the user later revokes that consent, she finds out that the app only works to a limited extent. Okay, so Yulia is asking if the accelerometer is necessary, then yes. So if the accelerometer is necessary, then you wouldn't face detriment because you would know that it is necessary for it to work, and without it, it cannot work. But in this case, since it's not necessary, and since the app provider is using the data generated by the accelerometer for other purposes, and it's not strictly not required, keep in mind what we said before, then the end result is that the user is facing detriment, and as a result, consent would not be deemed to be freely given. You wanted to ask a question, Kevin, on this point?
No, because I didn't. I thought we were still on example 1, but we were doing example 2 before.
No worries. I skipped example 1 because example 2 was a bit more challenging. Okay. Okay. Complementing the principles and requirements that we mentioned previously, consent must be given in relation to one or more specific purposes. Okay, so you must indicate the purposes for which you are seeking consent. So blanket consents are not permissible. So I cannot ask you, give me consent because I need it. I need to tell you why I need consent. Okay, I need to specify in detail why consent is required. Okay, keep in mind what we said before, that one of the data protection principles is that data must be collected for specific purposes, clearly defined and specific purposes. Okay, again, complementing what we just said, consent wouldn't be considered to be valid unless it is informed consent. Okay, and this is why in all circumstances, in all websites, when you create an account, whenever you download an app, there is a privacy policy. Okay, the purposes of the privacy policy is to outline why I am collecting data. Okay, it outlines the purposes and means for the collection of data. Okay? The privacy policy must be tailored to the audience which is being targeted. So if you are targeting, I don't know, the elderly, you cannot use words which or terminology which is text heavy, because the likelihood is that the elderly wouldn't be familiar with such terminology. Okay, you must tailor the words, the terminology of the privacy policy to the audience which is being targeted. Okay, another element for consent to be valid, consent must be a clear affirmative act given through an active motion or declaration. It must be obvious. So the act must be obvious that it signifies consent. Okay? So we have 5 examples here. Swiping a bar on the screen, waving in front of a smart camera, sorry, there is a spelling mistake, turning a smartphone around clockwise, pre-ticked boxes, and scrolling through a web page. Do you think that these would be considered to be clear and affirmative acts? Yes or no? We have 5.
I do not think so. Neither of them.
You think that neither of them is clear and affirmative act?
Neither.
Okay. Marek, what do you think, since you work in IT? And all 5 of them are quite common nowadays in the IT environment. So
I don't work in IT, but still I can reply. Information security.
Okay.
Swiping a bar on the screen, I'd say yes, it's a consent. Pre-ticked boxes, definitely not. But the others, I'm not sure.
Okay. And anyone else would like to give us their opinion?
In the case of scrolling through a web page, I think at the bottom, once you scroll through the whole web page, you have to accept or reject.
Okay. So
like Google, that's what they do basically. You have to go through all the terms and conditions, and at the bottom you say yes or no, I agree or not.
Okay. So as you said, scrolling through a web page for a considerable period of time was the method of choice whenever you accepted license agreements. Okay? It is not considered to be a valid consent, because in order for me to review the terms and conditions prior to acceptance, I must scroll through a web page. So you cannot assume that because I'm scrolling through a web page, I signified consent. Okay? There must be an additional act for my scrolling through a web page to constitute consent. Okay? In fact, what you are saying, probably when you scroll through a web page in Google, it would ask you to then click I accept. Correct? Kevin, were you pointing out this? About someone was pointing out that he encountered this in Google.
I was. It was me. So yes. At the end, you have to click on a button to say yes, I agree.
Exactly. So it's not just the scrolling through a web page. So the scrolling through a web page combined with a positive act.
That's right. That's right.
Exactly. So that would be considered valid. Okay. Pre-ticked boxes, no. Pre-ticked boxes are pre-ticked. So by them being pre-ticked, I am not signifying my consent. Okay. So pre-ticked boxes were quite common quite some time ago. They are no longer considered to be valid. The remaining 3, yes, they are considered to be valid, and they are in fact indicated as instances of valid consents in official guidelines issued by regulatory bodies. So swiping a bar on the screen, very common in apps. Waving in front of a camera, okay? Again, it's considered to be a clear, significant affirmative act. And turning a smartphone clockwise, it's also considered to be a clear affirmative act, okay? Joanna is asking, but you have no choice in reality, you have to accept. What do you mean, Joanna? Can you amplify on what you're saying so that we can?
You have to accept in reality. Like, for example, when you try to access a Google page or any other website, you have to accept, or else you're not provided with the. You cannot access the web page or the service provided.
You are asked for consent prior to accessing the service, okay? So you have full liberty whether to proceed or not. So in that case, it's still freely given in the sense that no one is obliging you to accept or not. What we're saying here is that you have full liberty, full discretion to review the terms and conditions and then to decide whether to accept or not. So very, very important. So what's important is that in giving consent, I am informed as to why the consent is required. So what Google is going to do with my data, okay? I am given a free choice whether to accept or not, and I signify consent by a clear and affirmative act. Okay? Understood, guys? Perfect.
So just to recap, so the first three, they are deemed to be a clear affirmative act of consent, right?
Yes.
Okay.
Yes.
And these guidelines, are they in the materials, in the resources they will gonna be given, so we can go through and read on our own? Okay.
Yes. And what I'm going to do, in fact, in addition to the slides, and wherever we discussed case studies, I will send you the correct answer, okay, for each and every case study.
Okay, thanks.
Okay, so as we said before, there are multiple legal bases on which you can justify the processing of data. So there are circumstances when you justify consent on multiple legal bases. So for example, consent and legitimate interest, okay? If a data subject withdraws consent, the controller cannot just migrate from consent to other lawful bases. Such migration has to be clearly specified and outlined in the privacy policy. So the privacy policy would stipulate that if you withdraw consent, I, as data controller, am still able to process your personal data on the basis of other lawful bases. Okay? If this is not specified in the privacy policy, you are not able to keep processing personal data. Okay? So this is just for your information. So what we did is we summarized. Okay, sorry for that. The 8 elements of consent, okay, which we have seen. Okay, we skipped one. Sorry for that. Okay, so in order for consent to be valid, funnily enough, we must also address the withdrawal of consent. Okay, So the GDPR requires that consent can be withdrawn as easy as giving consent. Okay? So let's take this case study. Supermarket offers an option to subscribe for weekly special offers by clicking on a yes or no button on its website. However, in order to ask for removal from such mailing list, I would need to call the call center. Do you think that withdrawal of consent is as easy as giving of consent in this case? Of course, not. Okay?
No, because I can see a asymmetry between the way that you grant the consent and the way that you wish to revoke the consent.
Perfect.
So you are making also from consumer care protection, you are making like more difficult to withdrawing.
Exactly.
Somehow.
I agree with you 100%. What to keep in mind is that it's not only not considered to be not good practice, but by doing so, funnily enough, you would be considered as nullifying the consent that you have obtained. So by making consent, the withdrawal of consent, more difficult, you nullify the consent that you have already obtained. Okay, so by making withdrawal of consent difficult, you nullify the consent that you would have already obtained.
So in the case of the supermarket, even if you got the consent, it's like void.
Yes.
Okay, so even if you have, because it does not comply with this principle, it's like not having anything.
Because in order for consent to be valid, okay, I must give the data subject the option to withdraw it. So by making the withdrawal of consent difficult, I would be considered as not giving the option to the data subject to withdraw his consent, and as a result, the consent in itself is challenged. Okay?
So basically, it has to be the same method.
Not necessarily the same method. Ideally, yes. But if for some strange circumstance the withdrawal cannot be given in the same method, it must be as easy. So it shouldn't be more difficult.
Okay. What if it's in the other case, for example, to give your consent, it's by call, and then to withdraw it by clicking, I don't know, but I think I'm complicating things here, but
no,
can it be done in that case or no?
Yes, it would be. The only issue that I can think about is possibly, let's say, the category of the elderly, that they might not have easy access to the internet.
Yeah.
So that's the only issue that I can think of.
Sorry, I have a question. I've seen some website, something like pop-ups saying that if you go ahead, I don't remember exactly the wording, but it was like basically, if you go ahead, you are giving the consent. This kind of practice, is it compliant or not?
Going ahead, but doing what then?
By going ahead through the website or login or get into the service is saying that you are giving the consent. So
is it preceded by the unambiguous and affirmative act? So
no, just you log in or you carry on navigating.
If you log in, so if you log in a username, so username and password, and click yes, that is a clear and affirmative act.
Okay.
Okay.
I got it. Yeah.
Any inactivity wouldn't be considered to be valid. So if I logged in a website, then yes, definitely a clear and affirmative act.
Mm-hmm. Okay, so the threshold is the clear affirmative act. I understand. Thanks.
Okay, so as we said, as we said before, there is a special category of personal data, the one which we said included data about health, about trade union membership, and about sexual orientation. And in that case, the law requires explicit consent. So not just consent, but explicit consent. Explicit consent is not clearly defined in GDPR, but whenever we're advising clients that rely on consent to process special category of data, we ask them to make sure that they obtain dual consent. So two different methods by virtue of which the data subject is signifying consent. Okay, so to make sure that we comply with this added explicit consent. So explicit consent means something more than consent. So in order to make sure that we comply with this added threshold, we ask our clients to make sure that they obtain two independent and different methods of consent. So for example, if we're speaking about the e-commerce environment, we tell them to get two-stage verification. Okay, two-stage verification meaning logging in and then receiving an SMS and inputting the SMS number or the number received by SMS in the app. So in that case, there is two-stage of verification. Okay, understood? Okay.
So the explicit consent replaces the consent, or I
No.
miss...
In the case of sensitive personal data, the special category of data, in addition to what we said before, there must also be explicit consent.
All right, addition, okay.
So in order to comply with this additional threshold, we ask for two-stage verification or dual consent.
All right, okay, thank you.
Okay, so we are going to assess the other legal basis that allows you to process personal data. So the second basis is the contractual legal basis. Okay, so processing being necessary for the performance of a contract to which the data is subject, or to take steps at the request of the data subject prior to entering into a contract. Okay, so as you can see, it deals with two different scenarios. So processing necessary for the performance of the contract. So the first scenario, there is already a contract. And the second scenario, taking steps at the request of the data subject prior to entering into a contract. So even if there is, if the contract hasn't been yet executed, if I am taking steps at the request of the data subject prior to the execution of the contract, I might be able to justify the processing of data on the basis of this legal basis. Okay? However, there is a strict interpretation as to what is necessary. Okay? Necessary means it must be more than just useful and must not just be part of your standard terms. So if there are less intrusive alternatives how to get consent, processing would not be deemed to be necessary. Okay? So we have an example here. Okay? A data subject making an online purchase. Okay? The controller processes the address of the individual in order to deliver the goods. Okay, this is obvious. In order to deliver the goods, the company must process the address. So the processing of the address can be justified on the performance of a contract. It is strictly necessary in order to perform the contract. Without it, I would not be able to deliver the goods. Qualification number one if the data subject chooses to pick up the items. So let's say a restaurant, I ordered food from a restaurant. However, I told the restaurant I am going to pick up the items myself, the food myself. The processing of the address no longer remains necessary. However, so in that case, if the restaurant needs to process the address, I think it doesn't need to process the address, it needs to justify the processing of the address on the basis of another legal basis. Okay? Again, qualification number two, sorry. If the restaurant wants somehow to profile my interest so that he can understand what food I like and not, again, it cannot justify the profiling on the performance of the contract, but it needs to seek an alternative legal basis. Okay, another example. Again, the same scenario. A customer returns an item. The company must process the history of the customer so as to be able to process the complaint. Okay, so in that case, the accessing of the history of the customer can be justified on the basis of the performance of a contract. Okay, so the second facet of the performance of the contract, as we said before, also includes taking steps at the request of the data subject prior to entering into a contract. Okay, so preliminary processing of personal data may be necessary before entering into a contract in order to facilitate the actual entering into that contract. Okay, so for example, if I'm using an app, okay, and or if I'm using a website and I'm checking the delivery fees before ordering on the basis of my address or on the basis of a postal code, if the company is processing my address or my personal code so that it gives me, it shows me the delivery fee, then yes, the company is processing the personal data, my address, at my request prior to entering into a contract so as to show me the delivery fees. Okay? Okay. So, legal, I have a question. Let's see the question. Okay, sorry, another question. So, legal basis number 3 is compliance with a legal obligation to which the controller is subject. Okay? So, requirements here, the obligation must be imposed by law and not by contract. So if I'm subject to an obligation because I'm subject to an agreement that I entered into with a third party, that doesn't justify my processing on the basis of this legal basis. Okay, I must be compelled to process that data by a legal obligation. Okay, so an example, in the case of employers, they must report salary data of their employees to Social Security or tax authorities. Okay, so in that case, the company is sending the data to the tax authorities because there is a requirement by law to do so. Okay. Another legal basis is vital interests. Okay, processing is necessary in order to protect the vital interest of the data subject or another legal person. Okay, this basically relates to questions of life or death, or questions that scenarios that pose a risk to the health of the data subject. So if I go to the to hospital the emergency department, I don't know, following a serious road accident, they don't ask whether I consent to process my personal data. It's a question of life or death. So they would be processing personal data on the basis of the vital interests. The scenario would be different if I book, for example, for medical care in advance. So if I book medical care in advance and the hospital would require to get my health data from a third party health practitioner, the likelihood is that this will not be justified on the vital interest, but it needs to be justified on the basis of one of the other legal bases. Okay, there is no urgency in that case, so vital interest doesn't come in play. Okay, last but not least, in fact, this is one of the more important legal bases, is the legitimate interest. Okay, processing is necessary for the purpose of the legitimate interest pursued by the controller or by a third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subjects, which require protection of personal data. And in fact, what we're doing here is, I believe we mentioned previously, CCTV footage of a cashier, correct? In a bank. So let's do a legitimate interest assessment in order to understand whether we are able to justify the processing of the footage of the cashier on the basis of the legitimate interest. So in order to carry out a legitimate interest assessment, I need to do three things, three different tests. Purpose test, am I pursuing a legitimate interest? Necessity test, is it necessary to process that personal data? And of course, last but not least, the balancing test. Does the rights of the cashier override the legitimate interest of the bank? Okay? So let's go over these points by assessing the example that we just mentioned. Point number one, so test number one, identify the legitimate interests. Why am I processing the data? What am I trying to achieve by processing the footage of the cashier? Okay? Who benefits from the processing? Are there any wider public benefits to the processing? How important are those benefits? What would the impact be if I'm not able to proceed with the processing of the CCTV footage? Would use of the data be unethical or unlawful in any way? So what do you think? In this, let's take the first set of questions. Why is, of course, easily answered. Who benefits from the processing? Are there any wider benefits to the processing of the CCTV footage of the cashier? What would the impact be if I'm not able to go ahead? What do you think, guys? Do you think that the data, the CCTV footage can be considered to be unethical or unlawful?
No, I don't think so. I think the shop owner or whoever is protecting his own interest, obviously, in case money is stolen or...
Okay.
I think it's his right. I mean, it's his property at the end of the day.
Perfect. Okay. Valid point. Let's proceed with the second test, necessity test. Mela. Does the processing actually help to further that interest? So we're saying that we are processing the CCTV footage so that we can ensure that the cashiers are not stealing money. Okay? Is it a reasonable way to go about it? Are there less intrusive ways to achieve the same result? What do you think? Three very important questions. Can I monitor that my employee is not stealing money by using less intrusive ways rather than CCTV footage? Keep in mind that the employee has the fundamental right to enjoy privacy whilst working. So yes, there is the legitimate interest that the bank must ensure that the cashier is not stealing. Is CCTV footage considered to be adequate? Keep in mind what we said before. Data must be adequate and we cannot process more data than required. Okay, here we are saying that in order to ensure legitimate interest, I must ensure that there aren't less intrusive ways to achieve the same result. So what do you think?
You can always put checks and balances to check if he is stealing.
Very good, very good. So let's proceed with the third test before giving a definitive answer. Okay. So in the third test, which is one of the most important tests, is the balancing test. Okay, so we are balancing the right of the bank or the expectation of the bank to ensure that people do not steal, his employees do not steal, with the expectation of the employees that whilst working, they enjoy a right of privacy. Okay? So what is the nature of the relationship with the individual? Is any of the data sensitive or private? Would people expect you to use the data in this way? Are you happy to explain it to them? Are people likely to object or find it intrusive? What is the possible impact on the individual? How big an impact it might have on them? Children data in this case is not relevant. Vulnerable individuals are not relevant. Can you adopt any safeguards to minimize this impact? And can you offer an opt-out? So keeping these balancing tests in mind, what do you think? Do you think that we are allowed to monitor the cashier's performance through CCTV footage? Do you think it's excessive? Do you think it's a reasonable requirement or expectation for the bank to have?
Sorry, I think also depends obviously on the premises and the business. It would make sense, for example, for banks to have such recording. Also, in case, for example, if there is any robbing, someone goes inside the bank and try to steal money somehow, not only for the employee.
Okay, but let's just very, very important point, Rafaela. But let's distinguish between CCTV footage for security purpose, okay, and the camera placed directly on the cashier to monitor their performance at the end of the day. So let's distinguish between the two. Let's, for the first scenario, let's just assess CCTV footage on the cashier.
I think on the cashier is a bit too intrusive, I think. You may also consider like it creates a kind of pressure psychologically on the cashier. So as an individual, I don't know. Perhaps you might find some kind of less intrusive ways.
Okay, very, very valid points.
And why you should focus the camera on her, on him,
okay,
unless you have a valid, you have a grounded suspect that she's doing or he's doing something wrong.
Okay.
So it might function at the second stage because you have a valid suspect, a grounded suspect that that person is doing something, is infringing or is even breaking the law, is infringing contract or internal policies or even breaking the laws. Okay. So at the second stage, you may start recording the footage, we start recording the images of this person.
Valid points. Someone else would like to give their opinion. Francesca, what do you think?
I think that in this case, the security of the bank supersedes the interest of the cashier not having a CCTV on him. So I think in this case, it's valid.
Okay. Anyone else?
I think as well it's valid in my case, because how is going to protect his legitimate interest in the employee? I mean, I can't think right now. Maybe right now I can't think of another solution. I might maybe tomorrow or something. I don't know. But right now, I am not thinking of any solution how we could monitor the cash, for example.
So monitoring of employees is a very, very sensitive subject. So the starting position is that when during the course of employment, so whilst I'm at my workplace, I have an expectation of privacy. Okay, so that is the starting position. Okay, all employee monitoring, okay, must be almost the last resort. So in this case, because we're running out of time, in order to justify CCTV cameras on cashiers, okay, because there could be a number of less intrusive means, most probably the only justification could be CCTV footage without showing faces, okay? So it's just showing that CCTV footage showing only the cash register, whatever it is, without showing faces. Because if you show faces and you are monitoring the activities of the employees, the likelihood is when you carry out the risk assessment in detail, risk assessment, you will find less intrusive means of achieving the same purpose. Okay, it would be a totally different analysis if the bank is placing CCTV cameras in order for security purposes. Okay, there is definitely a legitimate expectation which overrides the legitimate expectation of me as a customer whilst I'm in the bank. Okay. Okay, very, very important because of the accountability principle. If you carry out an impact assessment, a legitimate interest assessment, okay, document the steps that we mentioned, okay, because if something happens and someone challenges you, okay, at least you show the basis on which you made your assessment. Okay, and of course, in order to comply with the transparency principle, you must inform the data subject that you are basing the legal basis on legitimate interests. Okay, in the privacy policy, you must stipulate that you are processing, let's say, CCTV footage because of the legitimate interest to ensure a safe environment. Okay, even though we're exceeding we go. It's 8:30. If you have 10 more minutes or 5 more minutes, we have, I think, 3 more slides to go through. Okay, you have time, please.
Okay for me.
Okay, perfect. Let's go through these quickly. So as we said, the processing of the special categories of data is subject to an added layer of protection. So the other legal bases do not apply, but it must be based on one of the following legal bases. So as we said before, data subject giving his explicit consent. Okay, and we already mentioned what constitutes explicit consent. The second scenario where I would be able to process sensitive data, a special category of data, is where data is being processed is necessary for the purposes of carrying out obligations in the field of employment, social security, and social protection law. Okay? As we already mentioned before, health data can be processed to protect the vital interests of the data subject. Okay. Processing carried out in the course of legitimate activities by foundations and other not-for-profit organizations. In the case of data manifestly made public by the data subject, keep in mind the manifestly. So if the data subject disclosed sensitive data, you are able to use it, okay? But not accidental disclosures, but voluntary disclosures of sensitive data. Processing necessary for the establishment, exercise, or defense of legal claims. So that justifies processing of special categories of data. Of course, processing necessary for reasons of substantial public interest. And the first two, basically, if we take COVID as an example, processing of health data was being processed because of preventive or occupational medicine and also in the public interest in the area of public health. So public authorities were processing data in relation to COVID, and they were justifying that because it wasn't for reasons of public interest. Okay, that is about it. I have lost my voice, so if you have any questions, feel free to ask. No questions, Raffaele? You surprised me.
Well, I'm tired. I'm hungry as well.
So, if you have any questions, feel free to send them by email or send them via chat. I believe that if you send them via chat, they will be relayed to me by the administrator. So the next session will be going through the data subject rights, and we'll be discussing a number of case studies. That's about it, guys. So I believe we're all hungry and we're all tired. So thanks for spending 3 hours. As I said, it's quite sad not being able to see your faces. It's quite lonely. Alexander, is there any additional literature we should read? Not at this stage, Alexander. Thanks, Sarah. Okay, so thank you guys, and I believe I will be seeing you next week. Okay, thank you. Bye bye.
Bye.